are essentially very much concurrent with those expressed by Mr. Chauvel, but I must say they were arrived at independently in terms of our initial approach to the SOP 108. And I take all the points made by the Honourable Attorney General, and it is in light of his explanations that the Green Party has resolved to support SOP 108, but for the reason that was just cited, namely that it's not going to go into Select Committee and it will be dealt with here in the committee. I think it is very important, given the fundamental nature of what we're about here, that we do explore it a little. And I want to draw to the committee's attention the fact that the SOP would, in effect, specify that higher duties allowances are payable only to a judge who, and this is a drafting point, who is or was not a judge of the Court of Appeal holding office under the Act. The purpose of this is that such allowances will be payable and only payable to judges from the High Court serving temporarily on the Court of Appeal. I want to make 2 points, one essentially of drafting, I guess, and one of substance. On the first, and I may stand corrected, but if I'm right, the government can convey its appreciation later. It's just a point of syntax. A strict reading of the SOP would have the allowance paid only to judges who either are currently judges of the Court of Appeal or who never were. And that surely is not the intention. And I repeat the phrase, a judge who, quote, is or was not a judge of the Court of Appeal. Surely that's not the intention. Better to have it read, quote, payable only to a judge who is not or was not a judge of the Court of Appeal, end of quote. But enough of that. I'll leave that to the drafters. On the point of substance concerning the reason for the amendment, this is because of an administrative error recently uncovered, as has been noted. At present, the relevant Act refers only to permanent judges, and High Court judges who are temporarily seconded to the Court of Appeal do not qualify as permanent judges of that court. They are therefore, under the current legislation, not eligible for any higher salary when they serve in that court. So, Mr. Chairman, for the past 11 years, from 1998 to this day, they have been paid what has been called a higher duties allowance. The problem is that what they are being paid is not strictly an allowance either under existing legislation. But the Ministry of Justice, largely unfazed by the constitutional niceties back in 1998, got around the vexing problem by bureaucratic decree. To quote the Ministry, although the difference between the two salaries is labelled an allowance, it is not actually an allowance in the sense that term is used in the Judicature Act. The payment of seconded judges' salaries in this manner, i.e. using the administrative tool of a higher duties allowance, is done for administrative convenience, as it enables High Court judges to be paid the salary of a judge of the Court of Appeal while sitting as a judge of the Court of Appeal without having to alter the payroll system. The term allowance is used because it is one that is recognised by the automated payroll system. Well, fantastic. Just an administrative sleight of hand to solve a day-to-day problem. But is it? Well, no, it is not. In fact, the payment of this allowance has become an issue in the courts where it has been argued it has constituted an unlawful payment by the executive branch of government directly to the judge in breach of the ancient constitutional principle of non-interference with judicial salaries. And the Supreme Court, as the Attorney General noted, did rule on this in July 2008. In that ruling, the judge held that, quote, the constitutional importance of arrangements concerning judicial salaries is such that there must be a clear statutory basis for all amounts paid to judges by way of salaries and allowances, end of quote. Given the constitutional importance of judicial salaries, he considered that payment of an allowance to a High Court judge sitting on the Court of Appeal should rest on a more secure constitutional foundation than was apparent in the evidence before him. And the Attorney General has explained that essentially to all our satisfaction. The issue, said the judge, was the effect which the making of the payment, if it were unconstitutional, might have on the independence and impartiality of the courts. Such concern related to the constitutional position of the judiciary as a whole. So it is not administrative. It is not administrative trivia we are dealing with here.
Dr. Kennedy Graham.
Thank you, Mr. Chairman. It's not administrative trivia we're dealing with. We're talking about fundamental issues of our Constitution, as Mr. Chauvel has pointed out, namely the independence of the judiciary from the executive. It seems that for the past decade, New Zealand's constitutional stability has basically been held hostage to the whims of a computer programmer. Or, to put it another way, the payroll system of the Ministry of Justice was unable to accommodate our Constitution. The effect of all this is that the legislature is asked to retrospectively validate financial payments to the judiciary, which the executive, through administrative convenience, has made, if not unlawfully, then certainly on an insecure constitutional foundation. And that's the judgment of the Supreme Court. Clearly the government concurs, because if it did not, it would not be submitting the SOP to make payments rest on a secure foundation. So the outcome is that this House is being asked to retrospectively validate payments over the last 11 years. I have to say, Mr. Chairman, that I do not enjoy being asked to retrospectively validate anything, and certainly not financial payments to the judiciary, and certainly not when I'm being assured that those payments have rested on a shaky constitutional foundation. Given that concern, the Green Party did give consideration to opposing SOP 108, not because we oppose the payment to judges, not because we seek to keep the constitutional foundations or the separation of powers insecure, but because of a reluctance to endorse retrospective legislation. Now, the Attorney-General has recently been good enough to provide us with the authoritative work on retrospective legislation, Burroughs and Carter's work on statute law in New Zealand. The essential point in that work is that, in essence, retrospective legislation is objectionable only in three situations: if it takes away existing rights or defences, if it makes unlawful things that were lawful when they were done, or if it attaches a tax or liability to something done in the past. It seems that the higher duties provision in this SOP does none of those things. In deference to the authoritative judgment, we shall therefore support the SOP. But let us hope, Mr. Chairman, that we are not frequently asked. This is not intended as a rebuke of this government or the previous government, for that matter. It is more a call for greater acuity on the part of the executive, actually, essentially, which is where the problem arose from. Let us simply hope that we're not frequently asked to undertake this kind of retrospective wave of a legislative hand, to cast a veil over the accumulated shortcomings of a harassed executive for the sake of a resource-constrained judiciary. It's an unedifying action for all three branches of government, and the less we have to resort to this kind of thing, the better off we all are. Thank you.
The Honourable Leanne Dalzell.